You're not speaking, Ronnie. Morning or good afternoon, everyone. Hope everyone's well. Thank you for joining today's webinar hosted by Giant Group and MHC about all things Ireland relating to contractors and the temporary market. So we've got quite a few people jumping onto today's call. So we're just going to give it a minute or two whilst we let everyone settle in. If you've been on our webinars before, then I'm sure you'll be well familiar with the format. But if not, please do submit questions as we go through today's session into the Q&A, and I'll make sure we leave some time at the end of the session to push those questions across to both Charles and Ronnie as we go through. Still got people jumping into the call. The joiner numbers starting to slow down a little bit. So I think we're probably in a good shape to start. So good afternoon, everyone. Thank you for joining today's webinar about all considerations around hiring contractors and working with temporary workers in Ireland. Over the next 45 minutes, we plan to explore a range of topics that are impacting the use of temporary labour in Ireland and what that means in practice for both recruitment agencies, recruitment platforms and end hirers. We've broken up the session into a number of different topics. So the planned topics that we want to try and cover today is, first of all, we'll start with Irish auto-enrolment on pensions, which has just recently come into play. Ronnie will be able to give us some good insight into how that's landed. We'll then move on to the always the thorny issue of worker misclassification, with a particular focus on the Karshan tax status case in Ireland and what that means basically when businesses are looking at trying to classify workers as either self-employed or as employees. We'll then touch on some general legislation called the EU Platform Directive and how that's been thought about in Ireland and what impact that has on the use of temporary workers. And then finally, we'll finish off by a quick look at AI and how that is having an impact in the recruitment process for some, and then also impacting employment law based on the employment decisions that can be made as a result. And then finally, we'll move into the Q&A section. So please do submit those questions via the Q&A button, and we'll leave 20 minutes or so at the end to cover those off. So today's webinar is brought to you by Giant Group. We are a leading contingent workforce management company, and we've been operating for now well over 30 years. I'm really delighted to be joined today by Ronnie Neville, who works for MHC, which is a leading Dublin-based law firm who specialise in employment law and contingent workforce. Alongside Ronnie, we're also joined by Charles Dorr. Charles is the sales director for Giant Global, and Charles focuses on helping businesses of all shapes and sizes access talent globally and internationally using Giant's global international payroll services. So his clients will include a range of UK recruitment businesses as well as end hirers that look to place people overseas and globally. Myself, I'm Dan Haslam. I'm Chief Business Development Officer here at Giant, and I'll be the host, as always, for today's webinar. The format's pretty straightforward. We've got a list of set questions that I'll put forward to Ronnie and Charles, where we can weave through the topics that we like to cover. And then once we finish those topics, we'll go into Q&A. So as I say, please do put those questions in, and we'll get to those at the end of the session. So I think without further ado, guys, we're ready to get started. So if we could move into the first topic. Hi, Ronnie. Welcome. Hope you're well.
Hi, Dan. Hi, Charles. And hi, everyone.
Great. So first topic then, Ronnie, is Irish pension auto-enrolment. So it'd be great if you can give us a little bit of an overview of Ireland's new auto-enrolment plans and how the implementation's panning out.
Sorry. Just don't touch anything. I tried to touch something there and I got a panic that I couldn't undo my mute. Hi everyone, thanks for the intro, Dan, and a pleasure to join and participate. So in relation to auto-enrolment, this plan was rolled out with effect from the 1st of January, so it's pretty recent. It applies to all employers of all sizes, small and large, in relation to employees. Doesn't cover contractors. We don't have the worker status. We'll touch on that shortly. But it covers all employers of all employees who fall within the band of eligible workers, eligible employees. And that is that if you've got employees who are between 23 and 60, if they earn over €20,000 per year, and importantly, if they're not already participating in either a company pension scheme or their own personal retirement pension plan, PRSA, personal retirement savings allowance. So if you are not exempt because you're already part of an existing scheme, you're automatically enrolled. Revenue, with its payroll systems, knows who falls within those bands, age categories, remuneration categories, and you're automatically enrolled.
Okay, so on that basis then, how does the employer contributions obligation sort of differ from the UK auto-enrolment model, Ronnie?
My understanding of the UK, obviously the UK has had auto-enrolment for a number of years now, so you're up and running. Our ages are 23 to 60, you're 22 upwards to state pension age. Our state pension age is 66, so our auto-enrolment cuts people off sooner. Our threshold for earnings is higher at 20 compared to your £10, which means more people will be included in the UK or excluded in Ireland. Our contribution rates, perhaps unsurprisingly, because we're dipping our toe in the water in auto-enrolment for the first time, are lower. So in the UK, you're looking at 5% employer, 5% employee and 3% employer, total of 8. In Ireland, it's 1.5% employer, 1.5% employee, and 5% by the state. So we're looking at 3.5% contribution for those who are auto-enrolled. And then there's the opt-out period. It takes longer to opt out in Ireland, it's 6 months. And just to sort of explain how that's going to work then for Irish employees, you're automatically enrolled. You can't opt out until 6 months. The employer and employee contributions will immediately kick in and have kicked in from the 1st of January. What became really controversial is that on the eve of its introduction back in December, the state realised that the anticipated numbers to get set up for auto-enrolment were a lot lower than envisaged. They were anticipating 700,000 plus employees, and they were coming in at 300,000 or 400,000. And they realised that a lot more employers had engaged with employees and ascertained that they were already exempted. So the employees were inviting employees to either join the company pension scheme or put in place their own pension arrangements, with the result that they were automatically excluded. So that meant that anyone who has a PRSA or their own company contribution at much lower contribution rates than what the state wants, which is 3.5%, they didn't come within the cohort. They were automatically exempted from auto-enrolment. So government came in and said, okay, if you're excluded because you're already part of an existing PRSA or the employee is already part of the company pension scheme, we're now, and this was literally the middle of December, we're now going to mandate that you push your contribution rates up to meet the minimum 3.5%. So there was a last minute rush, absolutely awful for employers who were exempted from auto-enrolment and were thought they were tickety-boo. Immediately then, with only a couple of weeks and Christmas looming, had to rush to comply with these new minimum pension contribution rates, because the state realised belatedly that they deemed it to be a loophole. And there were some employment lawyers, not saying it was necessarily Mason, Hayes and Curran, but there were some employment lawyers who, when employers were tasked with seeking advice in relation to auto-enrolment, we were just observing that if you don't want to have a double pension arrangement system in place between your own pension and separately auto-enrolment, then why don't you invite employees to come in, strongly encourage, and then as soon as they come in on lower, so they could come in on 5.5%, for instance, then you were automatically excluded.
Yeah.
And government then closed the door on that.
Wow, I mean, timing would have been horrendous anyway. But then with Christmas just knocking everyone out for a couple of weeks, that's would have been busy times. Also interesting then that you say that the opt-out period is such a long period, then it's 6 months, which is double what we have over in the UK. Have you any insight as to what the logic there was for pushing out the opt-out period for so long, or?
Yeah, so everyone's been talking about pension time bomb for the last flipping decade, and it's a reality. So we've got a lot of different measures in Ireland which are belatedly trying to deal with the fact that people are aging workforce, pension time bomb, all this type of stuff. So there's kind of a twin track approach. One is to try to keep people in auto enrollment for longer, and that they don't want them opting out after the first couple of months, if that's what's the case in the UK. Certainly at 6 months, and as we all know, in terms of changing utilities, there's a degree of apathy. So I think that the logic is if you keep them in for 6 months, you're likely to keep them in for longer. And the second, I say twin track, there's multiple different efforts being made to deal with longer workforce issues. We've brought in a new act effective from December 2000, just gone, 2026, to the effect that employees now have a legal right to request to stay on from whether it's company retirement age 65 or 60. We still have a company retirement age that's lawful in Ireland, as long as it's objectively justified. I know in England they've knocked it on the head and made it unlawful to have a compulsory company retirement age. Still perfectly lawful in Ireland, but with this new act, the employee has a right to ask to stay on to 66, because there was this gap. People who were being forced out lawfully at 60 or 65 faced a pinch point because they were under financed between 60 or 65 and getting state pension at 66. So now they have a legal right to request. The employer can reject it, but the employer is now on the back foot and really has to have strong grounds to say no to an employee who wants to stay until 66, so that there's no gap between their own personal funding and the state's pension age.
Okay, yeah, no, that makes sense. So then, just now, sort of thinking about the topic, but with a specific lens on sort of contingent temporary workers. Have you got any advice for the businesses that are on the call today to think about how they should prepare for auto enrolment obligations when they're thinking about their temporary workforces?
It's probably going to become more relevant when we go into the next topics, looking at the risk issues we've been discussing amongst ourselves. And last year, the Karshan case, the code of practice, the different fora who have an interest and skin in the game in reclassifying what they believe are misclassified workers. And sorry, to bring that back to the pension piece, there's lots of consequences that will flow from a reclassification of misclassified workers, including employees, or what are deemed to be employees who were previously outside the net for tax heads by the client, which is now a new employer, including the pension obligation. So any of your client, any of the clients who are on the call now, or companies, intermediaries, or platforms, or agencies, anyone who is classified currently as an employee should have, under the Irish system, already been notified in the last week of December or the first week of January, and been told these employees are those registered from an Irish revenue perspective as being in scope for auto enrolment, and they are currently auto enrolled. And then it was up to, there was a frantic exchange in the first week of January where a lot of employers were reviewing these lists and trying to decide, have revenue got it right? So if anyone is concerned around those who were deemed to be in scope who shouldn't be in scope, or those who are probably more relevant who are not in scope because they're treated as contractors and they're not going through payroll, I think it just doubles down on the focus for the risk of reclassification, in terms of the costs that we're likely to face by reclassification across employment risks, but also tax risks, and now another one, which is and social welfare risks, and now another one, which is pension auto enrolment risk.
Yeah, totally makes sense, doesn't it? This is just another ripple effect of, once you've addressed the misclassification question, you've then got pension to consider and all the additional cost associated. So, well, without further ado, we should probably have a walk over onto the misclassification topic and start getting stuck in. So, obviously, when we talk about misclassification, we're talking about how a business establishes whether someone should be paid as an employee and taxed accordingly as an employee or as a self-employed individual. So maybe if you can just headline it for us, Ronnie, just give us an overview really of how in Ireland you determine whether a worker is an employee or genuinely self-employed, and then, and if relevant, we can reference how that differs to the UK IR35 framework.
Completely, yeah. So I don't know whether I'm doing Ireland a disservice or being, accidentally or unintentionally slagging off Ireland by saying that you've had a more sophisticated regime in the UK for many more years, and we're catching up to an extent. I mentioned earlier, you obviously have the worker status, so you're looking at the three different potential categories of worker. We only have the two. You're either a full-blown contractor, a full-blown employee with all of the trappings and rights that's associated with being an employee, being employment rights, tax effects of being an employee, social welfare effects of being an employee, pension effects of being an employee, or you're a contractor, where essentially the only employmentee rights that attach to a contractor are discrimination. Our Employment Equality Acts cover contractors in the same way that they do agency workers, but also full-blown employees. So historically, we had a situation where, this isn't new. We've talked about it before. I think in the context of an Uber case many years ago, I was on a talk for the IBA, International Bar Association, pontificating about the Uber case in the UK, and the King's Counsel stood up, or Queen's Counsel as he was then, and said, look, this isn't new. This is from a lawyer's perspective, the clients will cringe when I say this, but it's the gift that keeps on giving, because it is constantly evolving and challenging in relation to what is the old dynamic, worker versus employee, and now we have another, as a result of technology, a whole new added dimension to the difficult test, which is platform. And the Karshan case, which came out last couple of years ago, is what sort of raised this issue back, put it back in the spotlight again, because Karshan was a platform. It was a drivers for delivery, for I beg your pardon, Domino's Pizza. You're talking about platform type couriers or drivers. And what was interesting with the Karshan case is that essentially the Supreme Court, it went to the highest court of the land. It examined all of the historical case law that goes back decades. It essentially discounted one of the main tests that employment lawyers, it looks like on both sides of the pond, have been relying upon for many years, which is mutuality of obligation. And there was an old test under Irish law. We all know, are you under the direction, supervision and control? Don't wear the uniform, watch out for the business cards, try to have separation, make sure your contract is drafted well. But one of the biggest tests was, you cannot be an employee if you are what we call in Ireland casual. Casual is easy breezy. I don't have to work for you. If you ask me, if you invite me to work, it's up to me if I take the work or not. I'm properly casual. Equally, more fundamentally, there's no obligation on your part, client of contractor, to offer me any work, right? And that test for what we consider casual went out the window in Karshan, because the Supreme Court said, why have these historical cases and courts focused so heavily on mutuality of obligation? Essentially for these Domino's Pizza's drivers, if notwithstanding the easy breezy and casual nature of the worker's ability to subscribe, tick on the box and say I'm available, and the client's ability to say tick on the box and say are you available to take a job, notwithstanding that, what essentially the court said is you still look at these other core tests to decide if from the moment that those two sort of stars meet, that's when essentially the contract of employment comes into being. There is no mutuality of obligation, but discount it. You can still have a contract of employment in being, because these other tests are more important. What are the other tests? Does the contract involve the exchange of wages or the remuneration? It's a 5-part test, and now every client of ours who engages contractors generally, and of course in a more sophisticated arrangement, you're talking about intermediaries, platform, agency, umbrella arrangements, managed service companies, person service companies. That's the more sophisticated regime. But at its most basic level, what I'm saying to clients for the past couple of years is, do you engage contractors regularly? And if you do, look at the tests under Karshan, and look at those tests under Karshan which have now been adopted by as I mentioned, on our previous talk last year, we talked about the three interested parties who could look at this arrangement and cause problems for our clients, who are the clients of contractors deemed to be de facto employers, right? Who are those bodies? Revenue, WRC, Workplace Relations Commission, and Social Welfare. So each of those three, Revenue says, you're not a contractor, you are actually an employee, and I'm going to look for all the taxes I should have got historically. There's a 6-year look back period for Revenue, and who knows, maybe contractors didn't pay their personal taxes correctly, such that the client of the contractor is now potentially exposed to quite a significant historical tax exposure. Social welfare, same thing. You know, we're now going to reclassify you as being an employee, which results in much more significant PRS, essentially social insurance contributions, employer contributions, employee contributions, and my area, wearing my hat as an employment lawyer, is you now essentially give all these protections, with the most important one being unfair dismissal, to someone who previously had no protections other than the equality. So these tests are: 1, does it involve an exchange of wages or remuneration? 2, is it an arrangement where the worker is agreeing to provide their own services and not the services of a third party? So if it's personal services, and that's where the right of substitution comes in. If it's really absolutely, you know, genuinely an arrangement where, you know, you're being brought in as a contractor and as many contractors can provide those services, it fundamentally erodes this second core test for employee status. As opposed to, yes, this is a contract where I'm providing my personal services with limited, or maybe there's a right to substitution, but it's never actually implemented. And the core test number 3 is control. So control now predominates over mutuality of obligation, which has gone out the window. And then if the answer to those 3 tests is yes, yes remuneration, yes limited substitution, personal services, yes significant control by the end user, then the 4 and 5 are then you look at the terms of the contract, in terms of, you know, how the contract is performed, email address, uniforms, all that sort of, you know, holidays being taken, integration, etc. And then finally, is there anything else just in terms of legislative provisions that would result in someone not being deemed to be an employee rather than a contractor? So essentially, Karshan, those tests were adopted entirely without change by the 3 bodies, WRC, Revenue, and Social Welfare, put it into a code of practice, which I've described to you guys as being my Bible for clients, code of practice on determining employment status. And then, unhelpfully, they still, look, it's not really well drafted, because on the one hand it says each of these interested bodies who have put this together, WRC, Revenue, Social Welfare, they all have come together agreeing that these are the tests that should be looked at. Then there's a really, you know, unhelpful line to say that it's not necessarily binding. The decision of one won't bind another. And then we have a separate code of practice by Revenue, which is similar to, not identical to, this code of practice. So it's a real challenge. I know, sorry, I know I go off on one every time I go on it, but
no, it's absolutely. Well, you should do.
It's a struggle.
You should do as an employment lawyer. If misclassification doesn't get you going, then nothing will, Ronnie. So, but I think it's fascinating to hear what you have to say there. I was just, you know, thinking as you were talking about the comparison to UK. You know, we very much still focus very much on mutuality of obligations. So for that to have sort of gone out the window, or to at least be not given precedent in Ireland, is fundamental. And then right at the beginning, you did mention also the fact that, you know, over there you've got 2 statuses, whereas over here we have 3, and we have aspiration to get to a 2 status system, but it's very, very tricky when you've got one that's 3. So I think, to your initial gambit on who's winning, then maybe we could argue Ireland's got a pretty simple and straightforward process there. There's obviously no equivalent check employment status tool test, as in the CEST online tool that we have in the UK over in Ireland. There's no online portal that people can put information in. Instead, you have the Bible, as you referred to there, as a guide for people when they're thinking about misclassification, right?
Yeah, there isn't any, and unhelpfully in the revenue guidance, which is different to what I'm calling the Bible. But if you're concerned about revenue and tax, then, you know, you might then place greater emphasis on the revenue guidance note rather than this code of practice that I'm calling the Bible, Why? Because it doesn't give you the little helpful sort of algorithm or tool to input the data, but it really unhelpfully gives examples of sectors that are
Right.
more likely to give rise to a presumption of employment. Media, construction, couriers, delivery drivers. So, I mean, any client in those spaces will look at the revenue guidance and be concerned about the fact that revenue in its own guidance note, and you'd almost beg the question as to how they can credibly say this. What they're basically saying is, if you're in this space, you're probably an employee, but you might not be. And then follow your Karshan tests, your code of practice tests. But it just goes to show the mindset of revenue when they're already marking, essentially the public's or businesses' cards, that there's going to be a greater emphasis on specific sectors. So obviously we got that's published recently up to December of last year. It's updated regularly. Lots of clients, when that was updated with these sectors being highlighted, that caused the hairs to run, where they were coming in saying, now are we more exposed?
Yeah. Well, I think we're all familiar in the UK with how grey this topic can be, and very difficult to nail down in practice how a court may judge one way or the other. But that's all, of course, to the benefit of the revenue, whether that's the Irish or HMRC, in the sense that it keeps businesses on the toes. The risk profile is high, and the intent would be maybe there's a leaning towards employment as the safer bet. But I suppose on that topic, how exposed do you think recruitment agencies and end hirers are in Ireland when they're engaging people through personal service companies and sole traders? It'd be good maybe just to talk about anything you've seen from an enforcement activity perspective around that and the risk profile. Because I think when we did this call or this webinar 12 months ago, we were pretty relaxed that it wasn't top of everyone's agenda, but it sounds as though, especially through Karshan, that it really is moving further up the agenda for businesses now.
Completely. And the reason why it's particularly in focus is because revenue offered a moratorium to defaulting, unwitting and accidental misclassifying clients, or sorry, misclassifying employers. So those parties who, with the benefit of this guidance note, with the benefit of the Karshan rules, who, with the benefit of legal advice and probably tax advice, realise that, oh gosh, our historical arrangements, which we genuinely, without malintent, not deliberately tried to misclassify, but erroneously resulted in misclassifying by reference to this new lens under Karshan, revenue said, come to us, and sorry, I need to be careful, I don't know who's in the audience. Revenue said, you can make a self-declaration for 2 years, 2023 and 2024. Sorry, 2024 and 2025. If you want to declare and say, we've made a mistake, we've misclassified, we've had regard to Karshan and the code of practice, and we now want to mend our hand by bringing contractors into the fold, reclassifying them as employees. That opened up huge issues, right? Because all of your intermediaries, all of your self-employed folks needed an examination as to whether, with these tests, clients were safe to proceed as they were, or should actually say, okay, we need to look at the cost-benefit analysis. Cost-benefit number one, it gives you a moratorium for 2 years. What about revenues look back for pre-2 years? Cost number two, okay, well, if we reclassify them, how many employees, how many contractor now employees are we talking about? In terms of not just a revenue risk, a tax risk, but are all these reclassified new employees entitled to say, well, if I'm now an employee, where's my public holidays? Because as a proper sole trader people, different for your personal service company, because they will have been taxed through payroll if they're PAYE'd as directors, majority shareholders, or they may have been employees of managed service companies or personal service companies where they're just on the payroll as regular employees. But they may or may not, under the company intermediary arrangement, have been receiving public holidays and annual leave. So what we've been warning clients is, for pure contractors who never had public holidays, never had annual leave, they could be looking at your statutory rights. if an employer doesn't give someone their statutory rights for a public holiday, they've got a 6-month window to bring a claim. That's not that bad. How much public holidays are annual leave? But every employment right by statute is automatically an implied term of contract, and you can sue for breach of contract for 6 years. So for a lot of clients who engage multiple contractors in the tens or hundreds, the warning was beware of the law of unintended consequences, because you could be looking at claims by each new employee for huge employment rights.
Backdated holiday pay.
Backdated.
Yeah. Matt, I mean, absolutely fascinating. So I'd say, to summarize, the advice there, guys, is probably, if you're thinking of self-declaring to the Irish tax authorities, probably take some legal advice before you make that decision based on the impact that Ronnie's just sort of fleshed out there. Conscious, Charles, you've been sat really patiently as we're getting stuck into that, but I think you're as interested as I was to hear what Ronnie had to say on those topics. But perhaps it'd be good just to bring you in here and talk a little bit about, from your experience operating in the employer of record market and working for Giant Global, how you look at tackling misclassification more broadly, not just with specifics to Ireland, but just more generally when you're trying to decide how to engage someone.
Yeah, sure. I mean, I guess the reality is that it's not a topic just for the UK or Ireland. It is pretty much worldwide these days that you have, I guess, tax authorities wanting to put people into a PAYE type equivalent box because they generate more revenue that way for the country. And so most countries have some form of legislation or guidance around trying to move people in that direction. Essentially, what we did was look at things like IR35, look at WAB legislation in the Netherlands, the AUG legislation in Germany, a whole range of different countries, and kind of put together almost like it's like a questionnaire essentially to try and just give a guidance or to a client on, does this look and feel like an employee relationship, or does it look and feel like an independent contractor relationship? And certainly the sort of things that Ronnie was talking about around that, the whole supervision, direction and control, wages, etc. All of those types of questions are included within the questionnaire that we put together. But we've kind of tried to do almost a one size fits all as opposed to going country specific. Just to, and again, as I say, it's just to give people a guide. It's not seen as any form of legal guarantee that if you pass this, you're fine. It's very much a consultative approach to say, look, you've answered the questions in this way. This looks and feels like an employee relationship. You should go down that type of route. Or, you know what, this completely looks like an independent contractor. I think you'll be fine to do that type of engagement. Yeah. And actually, Ronnie, I was going to mention, I think when we spoke before, you mentioned about the limited companies in Ireland, that it wasn't so much the revenue that were particularly bothered. It was more the PRSI that were bringing cases because they were missing out on the employer contributions, but they felt they were getting their taxes from the limiteds, but they weren't actually getting the PRSI. And so, although it was passing on one side, it was then being picked up on the other. Is that still the case?
Yeah, I mean, I had a call with a client recently with my tax person on board, and I was concerned that she might take issue with the employment lawyer who's trying to discuss the risks for clients in respect of social welfare, revenue, and my own area, which is the employment, but also to interpret the somewhat confusing references in the Bible Code of Practice, because there is a section on personal service company, it's short. There is a section on managed service company, it's short. And anyone who's in this space needs to have regard to that and have regard to the revenue guidelines as well. But the limited succour I got, or comfort I got from the Code of Practice, was to the effect that, in general terms, those individuals who are providing services through a limited company, from a tax perspective, maybe not necessarily from a different perspective, but in general terms, are unlikely to be treated as employees from a tax perspective if they're already employed by, whether it's PSC or MSC, in circumstances where they're on payroll, and registered as employees, and that means they'll already should come under the rules for auto enrolment for pension, and will all be already set up as proper employees. Now, obviously, personal service companies, if manager, shareholder, single member companies, there's potentially a spotlight, and that's why I say the IR35 regime is more sophisticated, because my understanding is that that's where the IR35 regime is deliberately designed to focus on and attack, whereas from an Irish perspective, it seems like we're not there yet, and that we're still, at least from a revenue perspective, more respectful of the corporate veil, because it's a big thing for any third party to say, you know what, we're going to come behind the corporate veil, ignore the fact that someone is employed under a contract of employment, payrolled by this employer, and seek to attach employment status to the end user. We're not seeing that as regularly. So the careful tone would be, there is some comfort, but we can't, as lawyers, because we're waiting to see how this is evolving, say that that's your panacea to make sure that you come through a contract. But if I've got clients who are saying, Ronnie, any tips? I'm obviously saying, don't contract individuals as sole traders.
Yeah, for sure. I think it's really interesting when we look at this over various different countries. I always try and think of a bit of a scale, basically, as where all the different countries are on the journey around misclassification. And if this is high risk and this is low risk, I think the UK is probably a little bit more up this end. Netherlands is moving that way. Ireland's starting its journey now. It's probably over here at the moment, but it's all on its way too. And we know across all countries the direction of travel is shifting that way, because we're all getting older. We all need to pay social security, and that's the aim that the governments are focusing at. Brilliant. I'm conscious of time, and I know, Ronnie, you've got to go to, I think, an important call with 5 minutes to go before the hour. So let's move on to our final topic now. And a reminder to the audience, if you've got any questions, please start putting them into the Q&A, and we can put them across both Charles and Ronnie at the end of the next and final topic, which is just to have a bit of a look at the EU Platform Work Directive, and also how AI algorithms that are being used within recruitment practices are being interpreted in Ireland, and the potential impact on risk. So again, Ronnie, if we can come to you on this, as you're the expert, what's the EU Platform Worker Directive aiming to achieve, particularly in relation to sort of employment status and algorithmic management of recruitment processes?
Yeah, I think this is going under the radar. I think we're looking at two directives coming in this year. One is the Pay Transparency Directive, but this one, the Platform Directive, I think is much more impactful for clients generally, and specifically for those clients in the space that you guys are in. And where has it come about from? AI is now the subject of all these talks for the last couple of years, but even a decade ago, big employers, the Amazons, there's been cases with Estée Lauder in France, anyone who's using any AI algorithmic tools to assist in the HR function generally, right? Where do we see it? Recruitment, performance management, health and safety, and most importantly, most sort of jarringly, termination. So when you're looking at potentially recruiting people, we all know there's 1,000 CVs in. Let's cipher through them, pull out the best 50, and then interview the 50. But the problem is, these algorithms, and this is where the EU directive comes in. The Platform Directive tries to deal with three significant things. One, the misclassification issue for platform workers, which we touched on with Karshan. Two, the inherent unfairness in using AI in a manner which lacks transparency, and in fact there's been some really chunky decisions by not by employment tribunals, but by data, like in Ireland we've got a data commissioner and the equivalent in different jurisdictions, where they're imposing serious fines for contractor workers who are terminated or mistreated, discriminated against, when there's a lack of human involvement in decisions impacting on the workers, and then they're left flailing and either discriminated against or without employment or without work because of algorithmic decisions in respect of which they've got no right of audience or ability, no fair process and procedures. So the three things that this platform directive is designed to do is: one, focus on protections for worker status for platform and gig workers. Two, improve the lack of transparency when AI is prevalent, particularly with the use of AI platform or platform workers generally. And three is the data protection issue, because again, data privacy concerns, other than the AI and manner in which AI is being used. Obviously we're moving as Europe, maybe not in the US, much more towards greater protection for data privacy. Here are the three protections designed to come from this platform directive. My worry is that the scope is so broad that it's going to cover a lot more businesses than perhaps anticipated. So I'll give you a flavour of who are digital labour platforms according to the directive. It's any person providing services meeting these requirements. If the services are provided at least in part at a distance through electronic means, provided at the request of the recipient of a service, involves an essential component where the organisation of work performed by individuals in return for payment, regardless of whether the work is performed online or in a certain location. Now that online bit means that work performed in location is all the drivers, the Ubers, the food delivery services. But if it's pure online services, that brings sort of micro online services and freelancers much more into scope. And it also provides for the use of automated monitoring or decision-making systems. So that's really broad. And that means that it's going to cover not just on-location work like the taxis and the food deliveries, but also, as I say, freelancers or microtasking. And it also, it will apply, the directive will apply irrespective of the place of establishment if the platform is operating in the EU. And this is the most important one, and I'm going to shut up and let you guys jump in. The directive will apply even if there's no direct contract between the platform and the worker, or the worker and the service recipient. So it's specifically designed to prevent platforms avoiding obligations by having intermediaries. So now I'm raising an eyebrow and saying, okay, well, if you're going to attach these Karshan rules, worker employment rules, as long as they meet the tests under local legislation applying the directive, and you're saying you won't get away with just sticking an intermediary in between, and the rules will provide for the AI stuff, the worker status stuff, it's presumption of employment status, which is heavy. Who does all that liability attach to if there's an intermediary? It's not clear. And under Article 3 of the directive, it talks about potential joint employment and joint liability of the intermediary and the end user. So it's not clear under the directive as to whether, if you meet the tests for meeting the threshold for being a platform worker and might be deemed to be an employee, are you then going to be an employee of the end user, of the intermediary, or are you accepted as just being an employee of the intermediary with the other impacts of the platform directive, like the AI and the data protection protections, or are you looking at a joint liability situation? And no one has the answer to this. I went down a real rabbit hole over the last couple of days looking at this, and I think I'm going to be sort of interested to hear clients' own views on it. And it's due to come into law in Ireland from December 2026. So it's another new area of focus as to the effect for those who are in this space.
Yeah, I think everyone, obviously AI is moving at such a pace, not just, across all sectors and all parts of our lives, and everyone's wrestling with the impact and what that means. And yeah, it's real tricky. And obviously, you've talked about those grey areas. I think it's AI is going to prevail into processes, and people need to understand the risk around it. But it sounds to me, though, at least from the legal perspective, that the presumption of employment is the safest way to go. That said, and we don't really focus on that so much in these webinars, but of course there's a huge commercial impact that decision has on cost, and you can't ignore the commercial pressures around how people want to engage, and the fact that it's often the preference for people to be on a self-employed basis because of the reduction in cost. So it just creates tension in that supply chain, and it's for businesses to work through their own risk appetite as to how they want to process and engage those workers.
Dan, cool. I was just going to add there that obviously the other part of the Platform Workers Directive is, as you just said, that presumption of employment. So if you're ticking these boxes that Ronnie was going through, then as far as the directive is concerned, you are an employee, and it's up to the platform to then prove that you're not. So you do have also this kind of little bit of friction there happening, where you have got a workforce that wants to be mobile, wants to be able to move around and do what they want and take this role, take that role, and you also got end clients who want to have that kind of flexible workforce, but they're being put through a platform that will very often move them into an employed infrastructure and say, actually, you're an employee and you've got all these rights, etc. And then you need to look at an intermediary, maybe, or someone who's then got to provide that. So you've kind of got this, as I say, this friction happening between, we want a nice, flexible, quick moving workforce, but we want to put them in a formal employment structure, and they don't necessarily go together. So it'd be interesting to see how that develops over the next couple of years.
Yeah, absolutely. But from the volume of workers that we hear and see that are now, taking work through these gig style platforms, it's huge across Europe. I think it's several, tens of millions of people engaged, and the expectation is it will continue to increase. So it's a tension that's certainly not going away, and it's a way of working that many people are doing now and will get used to moving forward. Super. Well, that's the end of the topics. So we can now sort of move into the Q&A section to finish off. And I don't know if I'm delighted or disappointed to report that we haven't had any questions submitted from the audience. I think everyone's been sat there fascinated through the discussion around misclassification and through the topics that we've gone through. But we haven't got any questions at this stage. So I definitely do have one for both of the guests, which is, given what we've gone through today around the impact on Irish regulation, and one maybe for you to start with, Ronnie, is what single change in this Irish regulation do you think will have the biggest impact on contingent workforce models over the next 2 years?
Platform Directive, undoubtedly.
Yeah, it's interesting that you say that over and above misclassification. I would have thought that's the risk, but the two are intertwined and are not separated, are they?
Are.
That's the key, isn't it?
Yeah. So that's the single biggest legislative provision, and I'm answering that because I don't think the other thing, which I think you're talking about, which is that misclassification, I don't think we're going to see any new law other than the Platform Directive, which is EU based. I don't think we're going to see another Irish law to purportedly assist with the misclassification issue. I think that it's still something which is in its infancy in terms of looking at how the different fora are dealing with the code of practice and the different tests. So I don't think that's legislative provision. I agree with you that that's going to be most relevant. It's like the twin track. What would folks on this call, on this webinar, who are in this space or interested in this space, be most interested in? The evolution of approach by reference to what is essentially a new approach post Karshan. That's practically, but that's not legislative. That's how the fora are dealing with the new regime. Separately, from a legislative perspective, it's the Platform Directive, which, as we've just said, includes as one of its main components the misclassification bit. And just to add to Charles's input, couldn't agree more the way you said it. Everything. It's exactly that. And on the misclassification risk, on the presumption of employee status, wearing my employment lawyer hat, I can't speak to the tax and social welfare, but I've been in tribunal and in civil court when there's a presumption. There are certain pieces of legislation where a presumption is already against you, for instance, under unfair dismissals legislation. And I can assure the listeners and the audience that you don't want to be in a space where you're presumed against, because the burden is considerably heavier. Obviously, maybe that's self-evident, but don't underestimate it. You want to go in any case, parity. Plaintiff claimant makes a case, respondent defendant answers the case. If you don't make your case, it's a heavy burden. You've got to establish what's known as a prima facie case. Plenty of cases where you say, sorry, judge, has there even been a prima facie case raised? And if not, go away, dismiss. This new presumption of employment means claimant employee sits back, folds their arms, and says nothing. And the employer, end user, intermediary, whoever it is that's answering this claim, has all the work to do. In disproving a presumption, it's a very heavy burden.
Absolutely. Well, there you go, ladies and gents. I think what we've said here is the scene is set. It's going to be fascinating to watch how things play out in Ireland, both on misclassification, how the additional cost of pension, has an impact on your supply chains. Thank you, Ronnie. Superb today. We really appreciate your time, and to you as well, Charles. As always, we'll always follow up with everyone's contact details, and if you've got any questions, please do put them over to the guys, and we're happy to pick those up. But I think it just remains for me to say I hope everyone's enjoyed the session. We've got another one running next week, I believe, Charles, which is focusing on France. And then the week after, we've got one on the US. So they're now starting to come through thick and fast. We hope if you're interested in those areas, you can join us, and have a great rest of your day. Thank you very much.
Cheers. Thanks, everyone. Thanks, Dan, for arranging, and Charles.
No problem.
Cheers.